On June 9th, 2025, the federal court for the Southern District of New York dismissed a defamation claim against Justin Baldoni and Wayfarer Studios against the New York Times. And in deciding this case, they stated that the New York Times not only had litigation privilege, but also privileges and protections under the First Amendment. But what if there weren't protections under the First Amendment? So on September 12th, the New York Times comes running back to the docket saying, hey, even though the case is ongoing between the Lively and Baldoni parties, we would like you to enter a final judgment on our behalf as far as us, the New York Times, so that the clock starts ticking for appeals. And the court says, all right, Wayfarer parties, you have until October 24th to respond to the New York Times. She's the cutest dog in the whole world. You have till October 24th. They declined to do so. So the clock is ticking. Going back, what is this issue about? On or about December 20th, 2024, the New York Times publishes an article based on, but not solely reliant on, and that's important, a California Civil Rights Department complaint brought by Blake Lively. She alleges in that complaint not only sexual harassment, but retaliation, claiming that a smear campaign was going on in the media, and that in itself was unlawful retaliation for her claiming sexual harassment. And the article really centers around that idea of the smear campaign and retaliation. So evidence shows that the New York Times actually received thousands of pages of documents, not just what was filed with the CRD, right? So they were in possession of a lot of documents, and some of those documents might have been illegally obtained because the documents and texts were information taken from Baldoni and Wayfarer parties' communications with their publicist, Jen Abel. Abel, who had split ways with the publicist Stephanie Jones and JonesWorks, didn't know that Stephanie Jones had access to her text messages because Stephanie Jones said, that's my phone, even though you're leaving my employ, give me the phone, right? And Abel said, yeah, fine, here you go. Didn't realize that that phone was still connected to the cloud and still connected to everything she was doing. And Stephanie Jones was tracking her moves through the cloud and through her phone. The problem for Stephanie Jones here is that she may have violated federal wiretapping laws. Federal wiretapping laws are governed by Title 18 U.S.C. Section 2511. I am not a criminal attorney. If you have questions about this, go to literally anybody else. But let's just read some of the language. 1A applies to a person who willfully intercepts any wire or oral communication. Section B applies to the intentional use of devices designed to intercept oral communications, and subsection C provides any person who intentionally discloses or endeavors to disclose to any other person the context of any wire, oral, or electronic communication, knowing or having reason to know that the information was obtained through the interception of a wire, oral, or electronic communication in violation of this subsection shall be punished. Whoops. So, the statute goes on. We'll move on. So the information presented to the New York Times could have been illegally obtained. So that's important. Let's put a pin in that. That's going to be important for later, right? The question everybody had at the time of publishing this article was, how in the hell did Blake Lively obtain all this information, right? Did Jen Abel give her the information? Did Stephanie Jones give her the information? What's going on here? Did she get it through pre-litigation discovery and they had to turn it over? Well, an online journalist who Lively and her lawyers derogatorily and colorfully like to call mommy sleuths found the damning information. Blake Lively brought a complaint through an organization called Vanzan. Now, the complaint inexplicably sued only John and Jane Does, even though it was a contract claim. And these John and Jane Does were never filled in later with real people along the way, which is how you bring claims against John and Jane Does. You say, hey, court, I have good faith belief that there might be somebody that exists, a corporation that exists, but I'm going to fill that in as discovery goes on because I don't know who they are now. A good example of that is you sue somebody, you think they might be married, right? And you want to say they did it for the sake of the marital community. You would say John or Jane Doe for the spouse, and then you fill that in later. That never happens in this lawsuit, and Vanzan is not a party to either Lively Baldoni or Jones Abel lawsuits. So it appears that the lawsuit through Vanzan was brought for the improper purpose of obtaining wiretapped information and to avoid notice to Jen Abel, whose private information had been sought. In my mind, that lawsuit squarely violates Rule 11. I've not talked to a single lawyer who doesn't disagree with that analysis. In other words, most lawyers who I talk to this about go, that's super unethical. So who gave Lively and Mannett the idea that they should issue this subpoena to obtain the information from Jones, right? If the New York Times was the source of that idea, they may not be done with litigation yet, and here's why. So remember when I said the information presented to the New York Times could have been illegally obtained? The Supreme Court has looked at whether illegally obtained information published by the media is protected by the First Amendment. The case that really kind of squarely looks at similar facts is a case called Barnitke versus Vopper. I'm going to call it Vopper because that all is a mouthful to say. But that case determines this issue, where the publisher of information has obtained the information in question in a manner lawful in itself, but from a source who has obtained it unlawfully, may the government punish the ensuing publication of that information based on the defect in the chain. In that case, a couple of facts set apart what may have happened with Tui, who wrote the New York Times article, and Lively that are important for this analysis, right? So first, the media respondents in Vopper played no part in the illegal interception, right? In fact, they only found out it was illegal after they had obtained it and never learned the identity of the people who did obtain it. And second, their access to the information on the tapes was deemed lawfully obtained, even though it was intercepted unlawfully by someone else, right? So, keep in mind, there's really well-settled Supreme Court precedent that if a newspaper lawfully obtains truthful information about a matter of public significance, then state officials may not constitutionally punish publication of the information absent a need of the highest order. So, and that's the New York Times Company versus the United States, think Watergate, right? So this is a pretty high standard we're talking about. Barnitke and Vopper stands for the proposition that when a defendant who anonymously receives illegally intercepted information without present knowledge of its illegality has obtained it lawfully. Without present knowledge of its illegality. So obviously there are limitations baked into that decision. There are further limitations in a case called Boehner versus McDermott, and Cockrum versus Donald J. Trump for President Incorporated. Both of those cases have different facts around the awareness of the stolen information, right? So where does that leave us in Baldoni? First, the question is, what is the chain of events? If the information presented to the New York Times happened before that subpoena, and the New York Times or TUI said, you got to go back and get that legally, and then they did the subpoena, they received the information again, look at the subpoena and go, yeah, that's fine. There could be some liability there, right? Because first of all, they knew the information was obtained illegally to begin with. They looked at the subpoena. That doesn't actually square the issue of obtaining it legally because that case may have been brought for fraudulent purposes, to delay, harass, all that, right? So there's a question of, would the Vanzan bring it out of the Vopper protections under the First Amendment? And the question is, we don't know. But if Lively's attorneys did all of that on their own and then presented all of that information to the New York Times, there could be protections there. So that's a lot of what ifs, right? And I hope we get answers to all these questions within 30 days because that's how long the Wayfarer parties have to either appeal or file a motion for reconsideration based on new evidence that they likely received through depositions and discovery. So if we get that evidence, time will tell. Have the best day.